to collaborate with franchisors. Franchisors representatives and franchisee representatives sat together and decided, what is fair and unfair in these franchise agreements? Why are people screaming that there are unconscionable provisions in these contracts? I mean, the courts are dealing with an assessment of, is this unconscionable? And some of them are obscene. I mean, they are obscenely unconscionable. The court will throw them out, but the standard is so high, because you generally have to prove both substantive unconscionability, where it's completely one-sided, and you have to prove procedural unconscionability, where it's, hey, it's something unfair about how this was presented to the franchisee. And so it's a very high, difficult threshold, but you are dealing with it because some of these agreement provisions are so wrong. I mean, one-sided attorney's fee provision. If we get in a dispute, you pay our fees, you pay your fees, regardless of who wins. That type of thing. It's just hey, it's contract. You have a freedom of contract, freedom not to sign it. But there is people who get into these things, and if they become bound to it. There's a non-compete, they have their investment, they have to work regardless of their return on investment, that they're often being manipulated by the system. Now, is every provision of every law going to be perfect? No. Is the making of laws not particularly pretty from what I understand? And I'm not involved in it. I'm not a legislator, I'm not a lobbyist, but it's like making sausage. It's not always pretty, but what comes out can be a good thing. So, and I think we're here dealing with some franchise laws. Some of them, yes, there may be some overreach in some provisions of some of these proposed laws, but the basic underpinning of like good faith and fair dealing and giving a franchisee some rights before he gets the business taken away from him, that type of thing, I think is a basic level of fairness that, whether it's collaboratively or getting a legislator convincing them that this is necessary, I think both, can be done. Like, just as an example of some of the things, I don't know if you want to talk about this. There's like the franchisee Bill of Rights. There are certain things like good faith and fair dealing, uniform application, freedom of association, so the franchisees can get together and communicate and not be discriminated against.
Some franchise agreements disallow that.
And there's still, he talks about the FTC rule, which is a disclosure-based law, and it is an important part of franchising in this country. I mean, there's no question about it. But there's still a lot of, I guess I would say, leaks in that, where, for instance, franchisors will take advantage of contractual provisions, regardless of the disclosure, as long as I say that I can change that agreement upon renewal. They feel, regardless of what the old agreement says, I can make a completely new agreement. Franchisees have to sign it. I increase fees 100%. That type of, it's a problem. And can legislation kind of tighten that up? It's a relationship issue. So long as they disclose that they can do it, then they're scot-free under the FTC Act. So I think, there's a bunch of issues like the right to transfer without. Franchisors can often interfere with that right to transfer.
Can you explain what you mean by that? Can you expand on that a little bit?
Well, I always, I represent franchisees, and often a franchisee has equity built in that business, and he wants to be able to realize that equity. A franchisor doesn't always have that same interest in protecting the franchisee's equity, because it has its own brand, it has a buyer coming in. Does he want that buyer to pay fair market value for that business, or does he want to get pennies on the dollar? His relationship is going to be with the buyer, not with the franchisee seller. So there's some conflict of interest there. So can a franchisor, for instance, on renewal, increase fees 100%, change the marketing conditions, then the franchisee can no longer realize the value that he invested in this business. And there is that protection of equity is an important part of.
But if you're talking about equity, the franchise system is not an equity system.
Exactly.
A franchisor licenses to a franchisee the right to use their system and their intellectual property for a period of time. The franchisee invests money in that, gets a return on their investment over the period of the term of the contract, whether it's 5 or 10 years for the initial term and 5 or 10 renewal terms, and at the end of that period of time, they give the rights back, or they sign up on whatever the same circumstances are again. That's all it is. It's a relationship. That I may be misparaphrasing this, but I believe it was Bill Rosenberg who said in his book that if franchising were fair, franchisees would pay $1 million up front and nothing else for the term of the relationship. They can't afford to do that because they don't have the money, and so they do it this way. And he said that because of the statistics that are in the, I don't know if someone, maybe like Michael would have better knowledge of the stats than I do, but I think it's 70-some-odd% of people that start a mom and pop fail. 70-some-odd% of people that buy a franchise in a stable system are successful. That's what you're really buying. You're buying the right not to throw your money into a fireplace. And so this notion that there's equity to be built up into a system to sell at the end, it's just not the bargain that was cut in the beginning. And the reason for the disclosure law is so you know that going in. And I guess I just disagree with the basic premise that that's the deal. That's not the deal. Now that may work out, and I'm sure there are legions of franchisees who are generational deep, because if you're working in the Meineke muffler shop and doing a great job and your son wants to take over, and you're doing a wonderful job, why wouldn't the franchisor want to have you? I think, I agree with Greg. I think we're talking about minor examples of extreme situations and trying to legislate that in some sort of big brother fashion. I just don't think it's a brother thing.
Okay. Yeah. A couple things. One, I want to address Greg Rubenstein's comment that franchisees do not invest all their life savings. But there isn't a franchisor out there that doesn't require personal care. So it's not life savings. We're talking home, college funds. And there are contracts and clauses that talk about liquidated damages. So if that person was to cease operations, he would in fact owe royalties to the franchisor for the extent of the term of the contract. And those things take away people's homes and cause people to go bankrupt. And I have never understood how liquidated damages does anything to brand equity. Cross-default agreements, another issue that does not add anything to brand equity, yet puts franchisees in a very uncomfortable position if they're a multi-unit operator with multiple partnerships. So there are clauses in these agreements that can take away someone's life, their marriage, and even their life because of the problems. As far as your statistics, Scott Shane, University Wesleyan, disagrees with you, has for 20 years, finds that Michael's side and the IFA statistics are just not real, okay, because they're not based on fact. And you'll see there's indications that investing in a franchise is no better than investing in your own business. So I always caution people. Certainly, there are very high percentage success rates with certain franchisors, and I believe those franchisors are ones that operate with a collaborative environment where they're working with the franchisees for the benefit of the brand. And those are the opportunities that tend to work. It's not because of laws. Franchising exists in Washington State with one of the tougher laws. It exists in Iowa with one of the tougher laws. And it exists in Minnesota with one of the tougher laws that talk about good faith and fair dealing. So the fact that Greg says that these laws are not good are for franchisees and for the franchisor. I disagree with them totally, because they have proven to be successful over decades in other states.
So there, right there, is the fundamental rub. And I think Jim did a very good job of identifying the issue. But he also, I think, whether meaning to or not, said the absolute truth. It's not because of the laws. It's because of the economics of good systems and bad systems. Or, it's not even, when I say, so I should be more careful in what I say. When I say good systems and bad systems, I don't mean ones that are nice and ones that are mean. I mean systems that have a better economic offering than ones that don't. Franchisors fail too. There's no law that's going to protect a franchisor when it goes out of business. I mean, if legislation were the answer, we shouldn't have laws protecting just franchisees. We should have laws protecting everybody that wants to go into business. Because they fail too. And that's not fair. Because they put their life savings, or maybe they don't, or they have to personally guarantee the bank when they take out the loan. And they get into the same situation. It's not the laws. Systems that don't produce value for their investors, in this case the franchisees, will fail.
But sometimes they fail because of themselves as well, not just because of the franchise systems.
Absolutely.
Sometimes the franchisee is just a bad franchisee. And
There are bad franchisees, and guess what? I will say, there are bad franchisors. They've got bad models. They think they can make it work, and they can't. They cannot make the leap from operating a single unit that they just did very well on their own. I'm giving them benefit of the doubt, maybe they didn't. But they did great on their own. Like, I'm going to go franchise. And somebody sells them on. And they just can't do it. They're not cut out for it. I mean, I don't know. There could be 1.5 million reasons, but I've seen it. I don't know if you've seen it. I've seen it. There's no law that's been proposed that will stop that from happening. People will get burned. There will be franchisees who buy into that system thinking the franchisor knows better, and it doesn't. And it's bad. I don't want to see people fail. I don't take any joy in seeing either a franchisee or a franchisor go under. And this concept that somehow franchising is different than other business models. I mean, it is in the sense that you're getting a leg up. But for Jim to say that everybody puts their life savings on the line because they personally guarantee things, no. That's just not fair. Franchisees take loans too. They personally guarantee those. When the bank makes them do a personal guarantee, when I take my mortgage out, I personally guarantee that. It's not limited by just the assets of my house. When my house is underwater and I don't make my mortgage payment, the bank's going to look to me for my life savings and my IRA too. These are not unique to franchising. And therefore, I don't fundamentally see how this legislation that I've seen is the proposal. And again, all we have to go on is what's been proposed. It won't solve those problems.
What has been proposed that you don't like?
So I'll give you an example. Tell you, here's an example. Now, I should say, well, I certainly speak only on my own behalf. I did get a chance to review a lot of the bills, and I actually got a chance to meet with some legislators here in New England about some of the bills. And I learned something about the legislative process. I mean, I've been a lawyer for 15 years. I thought I understood sort of how that whole government thing works. I didn't have a freaking clue. One of the provisions that I saw a lot in, I think all of the bills, it may have not been in one of them, but it was in at least two, I'll tell you that, was a provision that, for example, said there's a very common clause in franchise agreements that say that we want to arbitrate instead of be in court. And we could talk for days about whether arbitration is better than being in court. I'm not starting that. But this is a provision in the bill that say, if the franchise agreement says you're going to arbitrate, you have to arbitrate in the franchisee's state. So I'll tell you, I've dealt with that clause before.
Franchisors.
Well, the bill says it has to be in the franchisee's state. Usually the contract says it has to be in the franchisor state, and the bill sought to change that. It wanted to make by legislation that it had to be in the franchisee's state. So I'm just going to tell you, that is flat out illegal. It's just illegal. There's a Supreme Court case. It's right on point. California's had this law forever and a day, and we just all know it's not enforceable. It just isn't. But we see it in these new bills, and so I think of it like, and that's where I got the, I don't know, I thought it was
It's not
amusing.
about arbitration, it's about,
It is, that's what the bill language you can't say it's not about something,
it's
Jim,
not
when
about
when it
arbitration,
says.
it's about litigation.
No, it says, if a provision in a franchise agreement, no provision in a franchise agreement requiring arbitration in another state outside of Maine, New Hampshire, fill in the blank, shall be valid, shall be void. That's the bill language.
The Arbitration Act of America,
The federal arbitration.
Federal
that one's
arbitration,
Which preempts
which
the-
preempts that
Yeah, that's
state
what he's
law.
arguing.
So you're arguing a new point because it's preempted.
So why did you put it in?
I didn't put it in.
You didn't have any role in that?
I've never been involved in drafting language to go
No,
I've
no,
always worked with franchisees, mostly on the brand side, and I've never been involved in drafting.
That's a good example of a couple provisions that, yes, I think that some provisions are overreaching. There's another one that tries to retroactively apply it to existing
Yeah,
contracts.
that's
Another
ridiculous.
huge potential.
But yet
they're
they're there. Hold on, I'll address this now, and they're there, and when there's a discussion about how do we aim with a rifle, not a shotgun, and it's no, we need everything or nothing, is the legislative discussion, like you all, I'm not a lobbyist either, but that's the conversation when I have my clients go talk about this bill in the legislature, they're saying, in all three states where I get clients to go, they're being told it's all or nothing. And so it's not just one thing, it's if you have one thing like that, like good faith and fair dealing is a good example. You say these states and it survived. Well, good faith and fair dealing is interpreted into every single contract. Why do we need a law that says that? Why do we need a statute when the courts are already doing it?
Because
With-
the
with-
contract
the
exempts it
contract
out.
says-
Yeah, but the courts won't
Wait.
enforce it. It's like California's law. It's not
No,
enforceable, so it's in there anyway, and it's a waste of paper, it's a waste of time, and it forces the franchisors to deal with things that, look, this whole discussion, the elephant in the room is the large franchisees from the large franchisors are fighting with each other. That's the fight. And they're using as pawns the little guys, because they know a large franchisor can't go in front of the legislature, and I own 150 franchises, and I'm making over $100 million a year, and I'm being victimized by the franchisor. I can't go do that, so I go get someone else to do it, and I fund it. Which is exactly what happened in Maine, and it's happened in other states too, and I'd be shocked if the guy in Pennsylvania wasn't funded by somebody who had money who wanted certain rights. When I had a client once, about 10 years ago, was thinking about getting into franchise, and they were being advised by consultants, and so they had me sit with them and talk to them about whether they should get into this industry or not, which ended up creating, they have 40 or 50 franchises now. Just think how many jobs that's created in our economy. They weren't going to do it. So I asked the consultant, why are you telling them no? I went to an IFA conference and I sat at a table with somebody, and he told me franchising is bad and I should never get into it. So I asked him who it was, and he said it was the president of this small franchisor named Appleby South. Okay, small. I'm pretty sure at the time Appleby South was a franchisee larger than Applebee's. So you had this enormous franchisee fighting with this franchisor. I mean, I'm guessing because I have no concept of how many they had, hundreds maybe, I don't know. But advising this small business, don't even start your franchise because of this fight. It's been going on for decades, it'll continue, and I agree with Rory, I'm sure there are instances where there's bad behavior by franchisors that have put franchisees in a bad situation. I'm confident you're right about that. And I agree with Greg, it's bad, it shouldn't happen, and in most instances, thankfully, they get rectified and people pursue their rights, and I'm sure there's some hiccups. But the overall system is working, and if you let the franchisors, the large franchisees, the large franchisors dictate the terms on everybody else, it's going to have a negative effect with lots of unintended consequences.
What's the franchisee community's general reaction to this? Not talking about these behemoths, but the general franchisee community.
Yeah, and again, whether it's big money on these laws, fighting, yes, franchisees do not have big money for the most part. There are multi-unit owners that do very well. There are some franchisee, some of my clients, they're bigger than the franchisor when it comes to the money. But those are certainly the exception, not the rule. I think when it comes to going to your legislator saying, hey, I need something to protect me, or, I think it's more of them protecting the smaller party in these relationships, which is the franchisee. And franchising is bad. Is that a sentiment that's going to grow? Yes, I think, if there aren't basic minimum thresholds of fairness. There was an effort to have franchisors agree to, hey, these are some standards of fairness you can place in your agreement. Some of them adopted, some franchisors adopted it. I would have to say most went the other way. Let's see how one-sided and arbitrary and total power to us can we put into this agreement. And every year, it seems like they take the old ones and add new, more one-sided provisions. And I'm not saying that it happens all over the place, but is there going to be a sentiment of franchising is bad, completely stay away from it? Yes. Is it going to grow? Yes. Are we in an economy now where it's not all perfectly easy to sell franchises? Would a law that provides minimum thresholds, a certain level of fairness, kind of quench that franchising is bad mentality, that at least there's some minimum relationship laws here to protect us? I feel more comfortable getting into franchising.
Has there been less franchisee issues in the 20 states that do have relationship laws now?
You can say people abandon Iowa because they passed the franchise law, but in reality, I've never.
Iowa's growing. It takes some statistics, some real analysts, and the IFA has published some reports. I know there's a number of people that find that the IFA numbers are way overstated. For instance, in Maine, they're talking about 3,500 franchisees in Maine. It's really only 1,200. So, but that report that the IFA publishes says 3,500. So, and even if you add the gas stations and the automobile dealerships, which both have protection laws in the state, as well as equipment dealers, as well as sports dealers, mechanized sports dealers have protections. And the reiteration of the law in Maine was to copy the Automobile Dealers Act and use that language to attempt to copy that law in saying Maine has had this law since 1970, has protected auto dealers from manufacturers.
Right, but you're making my point. General Motors, Ford Motor Company, Honda, and Chrysler are behemoth franchisors with essentially an oligopoly in the industry, and so that's what the law was created to protect against. This is not.
Japan and Korea would disagree.
No, I keep going in the list of it. Before they came in, that law was created in the 1970s when those big three auto dealers controlled the country. So you're talking about the responsive, that comparison to a small franchisor based in Maine like Amato's, which has 30 or 40 franchises. If that bill passed, it would have put them out of the business, they would have let people go. And that legislation is like applying a sledgehammer to this glass in front of me for that system. And you're making my point for me, I would say. I don't know what Mike wants to say, but
Michael,
you're making my point for
You're
me.
making a representation, you can't back it up.
Sure.
Well, the other deal, for disclosure, I actually am the expert for the auto